Good morning, good afternoon, good evening, everyone. A very warm welcome to today's webinar on Patent and Trademark Prosecution and Enforcement. On behalf of International Intellectual Property Law Association, I'm delighted to have you all join us today for this webinar. We have an excellent session lined up focusing on how to effectively navigate the IP application process and build strong, enforceable portfolio in today's evolving legal and landscape. Before we begin, just a quick housekeeping points. This session is being recorded. All participants are requested to keep themselves mute. In case if you have any question, you can share your question in the chat box or you can send it directly to me. We'll take them during question and answer segment at the end. Now let's start with the webinar. It is now my pleasure to introduce our esteemed speaker, Dr. Shilpa Arora. Dr. Shilpa is a registered patent agent, advocate, and trademark attorney with over 19 years of experience in intellectual property law. With a strong background in medicine and pharmaceutical regulatory affairs, she specializes in patent prosecution, global IP portfolio management, and complex litigation. Dr. Shilpa has extensive experience across pharmaceutical, chemistry, biotechnology, and medical devices, and has presented leading global companies in high stake patent dispute before various high courts in India. Today, Dr. Shilpa will share her insight on patent and trademark prosecution and enforcement. This session will provide practical guidance on building strong IP strategy and ensuring that your rights are not only protected but enforceable. So, without further delay, I invite Shilpa to take this session forward. Over to you, Shilpa.
Thank you so much. It's a pleasure to be here and to discuss this very important topic. So, as my background has already been discussed, I would not delve into that further, but just to add that what has already been said, that I practice across various forums and I specialize into patents and trademarks domain in for representing my clients in pharmaceutical and agrochemicals domain as well. So, without further ado, just to understand my audience, I would like my audience, the attendees here, to just type in chat box like whether they're a patent agent, they're a startup, or they're an attorney, or they're an advocate. Just some, I want some interaction also. Without me in verbatim, just talking about what my topic is. So, if I encourage all of you to just type in chat box what do they do? Like, are they patent agents, like advocates, or what you all are doing? So please, I invite everyone to just share in the chat box. That will help me navigate my conversation on this particular topic. Can I have some inputs in the chat box, please? I'm waiting. Great. IP attorney, legal consultant. Thank you. I encourage everyone to just mention that so that it will help all of us to categorize my discussion. IP attorney, yes. Attorney, yes.
Yes.
Majority towards the attorney side. Okay. Advocate, great. So more votes on more of the attendees on the advocate side and the attorney side. IP attorney, patent agent, great. So I'm happy most of the people here who are attending this session are either patent agents or they are IP attorneys. So they are well versed with the particular topic which we have in hand. So thank you so much. I will now start my session with this particular presentation which I have prepared, attorney and government counsel. Very good. So now I've got a gist of what all your background is. So it will help me a lot because if I want to delve into much technical details, that this will now navigate the discussion further. Let's start with this. I'm sharing my screen with the PowerPoint presentation which I prepared. Let me just screen share that 1 minute. So, our topic of today is patent and trademark prosecution and enforcement. A look at navigating the application process and building a portfolio that can stand up to the enforcement challenges. So now, what we understand from this topic itself shows that there is a direct link between the prosecution of patents and trademarks, any IP right, I would say, not just patents and trademarks. You have your prosecution going on, and that directly links your prosecution with the enforcement. So today's topic talks about those subtle points which we encounter during prosecution and how they impact the enforcement. All these points which we undertake during the prosecution, whether it's a claim drafting, whether it's claim amendments, or whether it's your admissions, submissions which you make before the patent or the trademark office, those are all directly related to the enforcement of your IP right. We will look into that in further slides. So just a brief, I'll move on to the next slide. What is I will be covering, what is that I will be covering in this particular webinar. It's a small introduction. First of all, I will deal with the strategic patent prosecution, what all we need to undertake when we are preparing any draft which has a commercial value, especially the patent application, the specification draft. Second is what kind of prosecution decision attorney must take, which helps in a enforcement better. Then how do you manage your patent portfolio and the risks? Then we move on to the strategic trademark prosecution. And then we'll be discussing about how we can carve out a enforcement ready IP portfolio. After that, we'll be discussing some enforcement readiness and what are the future trends and the current trends which are affecting this enforcement and prosecution. So let's start with this. As you know, this enforcement and prosecution, they have a direct link together. But usually what I've seen in my practice when I was in the initial years, I must admit here, then I looked prosecution from the completely different point of view. Like you just have to file it and then you are done. Because at that time, enforcement was not that great. There was no IP codes. The enforcement was really in the nascent stages. So with that in mind, I would say in today's age, when we have specialized IP codes, we have all the enforcement which is going on before the courts. Those those decisions which are pronounced by the courts are directly delving and discussing the prosecution. So the moment your prosecution is weak, your enforcement is also automatically weak. Your strategy also goes back. So with the message in this particular webinar is the prosecution stages, they directly impact your enforcement, not just what you are drafting, but whatever you are doing, even if it's like your searches. If you miss one critical prior art, that will weaken your patent, even if it's granted. Because what happens is patent is there's no prima facie evidence of validity before the court when the patent is granted. So it's always vulnerable to challenge. Just give me a minute, please. Yes. So I was on the topic that the patents are always vulnerable to challenge and there is no prima facie evidence of validity. So whatever is being done has to be done before you are enforcing your patent or a trademark. Let's say I'm the key strategic considerations which I mentioned in slide number 2 are enforcement starts at the drafting stage. So I would really say it's just a one step ahead, like before the drafting stage. You have to search, you have to conduct your trademark or a prior art search also for patents before you even get onto the drafting stage. And once you are drafting, you have to look into various stages. Like in patents, you have to see what your claims are, whether it's a broad claim or a narrow claim. How many dependent claims are you carving out? Whether it's a product or a process, or what kind of claim you will finalize at the time of filing. What kind of claim you will keep before the Indian Patent Office? What kind of claim you would keep before the international filing, the PCT, or any other international patent office for that matter, USPT or EPO, whatever. So you should have a clear understanding of the client's business. If they are into operating into the international sphere, you must carve out or draft the claim set according to their international strategy, so that the claims are drafted in a manner they can withstand the scrutiny before all the foreign patent offices, the Indian patent office, and should also be enforceable, because once you have a claims in place, amendment can only be limited to either a disclaimer or a correction or an explanation. You cannot have a different invention altogether by virtue of an amendment. So the carving or the drafting of the application, patent application, the specification has to be very thoughtful, very thorough, with all the data right in place to enable the patent to withstand the scrutiny before the courts and before any authority. So every amendment has a long term consequence. Please bear in mind, it is not a ministerial act. Okay, मैंने ये delete कर दिया, I have done that, I am just going to it's a simple deletion. Every deletion also is important, because you are asking the patent office or the trademark office, okay, I'm deleting this thing. You are narrowing down your scope, be it your trademark goods or services description, be it your claims. You are giving away that to the public. Every deletion you are giving to the public, you are disclaiming that. And whether any further particular ingredient has been added to your claim set, you are further narrowing down and weakening your enforcement. Because let's say third party comes up with the same claim, and since you have narrowed down your claim during the prosecution, that will directly affect your enforcement, because a third party may now say, okay, I have not used this particular ingredient, I've used some other ingredients. You're caught by prosecution history estoppel. So that's why every amendment you undertake during the patent prosecution has to be looked through a lens of the enforcement perspective. Now, like it says in the slide, that registration is only one milestone in the IP life cycle. You should not look at the prosecution from merely registration. Okay, registration is done, it will have a better enforcement. No, it's not like that. Like I mentioned, patents, they're always vulnerable to challenge. There are various provisions in the Patents Act, like you have revocation, you have post grant opposition. Even in the trademarks, you have cancellation, trademark cancellation procedures, and also on ground of non-use or XYZ ground before the court and then before the registrar also. So both the authorities, both the forums are available to to any third party to seek cancellation of the trademarks. So registration is only one milestone. Next, we go on to the other slide. The patent prosecution is a strategic decision making. Like I said, you have to understand your client's business very clearly to even evaluate or make further strategies on the patent prosecution side. Let's say in this particular, we have to consider these following things: defining the scope of protection. Let's say your client comes up with a particular invention. Okay, I have come up with the, let's say, a weaving machine, and this machine weaves the cloth in a much faster manner. Okay, then the client will say, okay, I just want the product patent to be there. But what about the process? What about any other subsequent part of that particular machine you want to protect? So you have to advise the client that, okay, client wants a particular product, but you have to see whether this part of that machine is also protectable, that is also patentable. That is for the attorney to decide and advise the client that what should be the scope of protection. It's not just the one particular machine you have to carve out as a claim, but you have to take into consideration the entire scope. Then we have to draft the commercially meaningful claims. What is the meaning of that? Meaning of this is that meaningful claims always have a separate, like how the you have you seen a funnel, like first a broad claim and then a narrow claims. So in that, claim dependency is also important. Apart from that, what kind of scope of the dependent claim is also important. Like I mentioned, you are taking a product claim and a process claim, and then further application claims are also there. You have to understand that what is in the dependent claims should be added, so that in case in the enforcement stage your claim one is rendered invalid, your dependent claim still remains valid, because it is all the claims which have to be looked into by the courts when you are enforcing your particular patent. So you have to be very mindful of what is in your dependent claims. Make sure when you are making or drafting these dependent claims, you are adding one step at a time, not a very narrow dependent claim. Whatever is your commercial invention, what is your commercial product, that should be carved out not just in your claim one. Don't put everything in claim one. Put it in a meaningful claim manner. One aspect should be there in your claim one, which is the broadest claim. Then your dependent claims should have at least one feature which should be able to protect your claim one in case it is susceptible to invalidity. So that is again a exercise which is entire lengthy topic which we can get into claim drafting. Then we'll speak on this balancing broad protection with patentability. Let's say your client says, okay, I want this particular treatment, I've come up with this particular treatment, but that is again a method of treatment is not allowed in India. So you have to see whether this particular invention is susceptible to patentability or not. If you cannot get it in India, how you can get that in India, because you have to protect the client's interest. And then how you can get that particular patent if it is permissible, if it's wanted by the client. You can advise the client to get into X, Y, and Z countries if it is allowed there. Then building fallback positions. Like I mentioned, you must have a thoughtful dependent claims to have a fallback positions. Managing prosecution history and international prosecution strategy. So coming back to managing prosecution history, every statement, every word you say in your examination report response is very, very important. I have seen responses from so many firms, from so many lawyers, from so many attorneys. They are just saying, okay, my invention is different from this. We have to be very specific why your invention is different. The minute you say my invention is different in A, B, and C, you are limiting your invention by those features A, B, and C. Please be mindful of this, because those A, B, and C, if those are different in your competitor's invention, then there is no infringement. So you have to be mindful of what you are distinguishing of your invention from those of the prior arts. Be very thoughtful in making a distinction of the prior art with your invention. Just choose limited and the key technical feature of your invention when you are making such statements in the prosecution during the examination stage. Now, international prosecution strategy, as I mentioned, that having an international patent portfolio or not, that's a strategic decision which the client has to take in consultation with the attorney. Having an international portfolio also gives a leverage to the client's business if they are having a market for that particular product in that particular jurisdiction. So that is also important. And then I'll go to the next slide. So I've just prepared a impact of the various prosecutions in the enforcement stages to help you gauge as to which prosecution will impact what. Let's say claim amendments. I've already told you. It determines the infringement scope. Specification support, if it's there or not, if it's not there, definitely your patent is susceptible to invalidity under the sufficiency of disclosure. So make sure when you are gathering the data or the invention disclosure form or the data which you're asking from the client should be able to withstand the challenge of invalidity, should be have enough data to support your claimed invention. Arguments before the patent office, again a prosecution history estoppel may apply and may limit your litigation position. Divisional strategy, which we have not talked, so it's also important. The moment you give a certain part of your claim, okay, you submit before the patent office, I'm deleting this particular claim. Check with your client. Are they willing to get into the divisional aspect, divisional application aspect? Because if there's a multiplicity of invention, objection raised, provided, because this is settled position now, if there is more than one invention and there is an objection raised by the patent office, you can get back to the client, ask for whether they're interested in filing a divisional application. Because if you don't do at that stage, then you are not able or entitled to file a subsequent application covering that subject matter which you have already deleted or given. So opting for a divisional strategy is giving you additional protection opportunity. Next, we come to claim hierarchy. Claim hierarchy, I've told you, like think from it a funnel perspective, which is capable of enforcement. This gives you much more flexibility during the litigation. Next, we get on to building an enforcement ready patent portfolio. So what should be your patent portfolio about? It should be strategically protecting your core technology. Like I gave you the example of the weaving machine. So the machine itself should be there in your particular claim subject matter. If this particular let's say if this weaving machine gets out of patent, like the 20 years expire, what is the portfolio of the client looking after that? So that also should be looked into. There should be whether there are any improvements to this particular machine or the particular product, whether there is a process involved in that particular machine which is doing that certain process, then whether there are alternative embodiments, whether there are any commercial embodiments, whether the commercial embodiment has been protected by a specific or a separate claim. That is a very important part of your patent portfolio. Again, future innovations, what is the client's line of business, what are they developing further, and whether they want to get into international markets. And most importantly, proprietary know-how. You cannot put everything, your eggs in one basket. You cannot say, advise a client, okay, file patents for whatever you have in their technical patent portfolio, whatever you're inventing, put everything under a patent basket. No, the client has to be advised on what should be protected, what should not be protected, and that what should not be protected is the client's trade secret. That is the technical know-how of actually how the invention, which they have, the nitty-gritties of that particular aspect of that invention has to be understood from the point of view of a trade secret. Whatever is there from the whatever is distinguishable from the trade secret, ask the client what they think cannot be reverse engineered by the third parties. That should be there in the trade secret bucket. Now, next, the outcome of the building a successful patent portfolio is a broader market exclusivity. The client gets to have a broader market exclusivity, and they have increased licensing opportunities. You have a good patent, which you have a strong patent, or a very strong trademark, gives the investor, the third parties who want to invest in your IP, a much better deal for a licensing opportunity. There are higher barriers to a competitive entry, because the thicker your patent portfolio, then there are multiple barriers for any competitor to enter into your IP domain. The stronger is the litigation position. Next. Now, there's a question. The two companies, they have the same technologies. Both have patents in their own. Let's say one have 15 patents, one have 20 patents. 5 years down the line, one secures a nationwide injunction and the other loses its infringement action. What made the difference? The answer was not the invention, it was the prosecution strategy. So don't get into the assumption, okay, I have 100 patents, the competitor has only 5 patents, or maybe 10 patents. So I'm a much stronger party. Maybe your patents are much weaker. Maybe your patents are not even covering the invention or the technology which is there in the market. So always think in mind that the patents or the marks which you have of your client should be strong enough, and the same time material to the client's technology and business. It's not just the number, it's the quantity which matters. Next, the trademark prosecution part, very interesting. Beyond registration, strategic considerations. So strategic priorities are listed here: distinctiveness, specification as a strategic asset, global filing and portfolio, evidence architecture, defensive filing. So I'll be very brief here. What I mean by strategic priorities, when you're advising the client on the trademark prosecution part, for an effective enforcement, it's not, in some cases, barring some cases where you have to take a descriptive mark, but there are certain instances there how you can turn a descriptive marks into a stronger mark. That is a subject matter of a separate discussion. But always opt for a quite a good distinctive mark, so that which can withstand an enforcement action. And then specification as a strategic asset. I've seen many companies just blindly copying the niche classification and pasting the trademark classification. No, it should not be there. First, a thorough search should be there. Then, after the search, if you think there is a close mark, what is the difference you can carve out in your specification of goods or services to enable you to limit your specification, so that the chances of the registration are much higher, chances of enforcement, winning in enforcement are much higher, but it should not be that narrow so that you cannot enforce it. So, drafting of the specification of goods and services which you have in your trademark application is very important. People often neglected, IP attorneys often neglected, okay, it doesn't matter, you just copy paste the entire niche classification. What will happen? You will have to delete it. No, you have to be specific. You have to be specific in the category. And in case the user is required, you will have to establish your specification of goods and services with respect to that particular user. Yeah. So make sure. Yeah, please. Okay. Any question here?
No, no, no. Please
Okay,
continue.
I'll continue. Thank you. So, the user has to match with your specification of goods or services. Next point is your global filing and portfolio governance. That means if you're filing an application in India, you have a sufficient time to get into the international filings also. So, please bear in mind whenever you want to file for an international application, and also have your client understand the importance of securing a mark through a Madrid, securing registration through Madrid protocol, or you want to have a mark registered in specific countries. So it's important to have the evidence architecture at the same time. That means you must ask the client to preserve the evidence of use of that particular mark, so that there is an effective enforcement. It's not just that you have registered, got the registration certificate, that is good enough. No, that's not just good enough. You have to, excuse me, you have to preserve your evidence of use, so that when at a later stage when you're enforcing that mark, you have enough evidence of use. Next is business outcome of all this is market exclusivity, enforcement leverage, licensing and brand monetization, long term enterprise value. I would not get into the details of that because that is very understood to all of you. Next is, so common portfolio weaknesses I've listed out in patents. As I mentioned, extremely narrow claim scope will lead to a difficulty in pursuing your enforcement when you're enforcing it against a competitor, against an infringing party, because your claim is too weak and too narrow. Then weak drafting support. Whatever you're claiming should be supported by your specification and should be completely be in consistency with the requirements of section 10.4 and 10.5. So whatever is mentioned in your claimed invention should be have enough support in your description. Then lack of continuation or divisional strategy, not knowing when to file a divisional and when to skip it is also important. Then we have inadequate international coverage. You have to advise the client of when and when not to get into the international stage, depending upon the strength of your patent also. Then you have a trademarks. What are the common portfolio weaknesses in trademarks? Whether it's a narrow specification or a very broad specification, then you're spending money on deleting the goods. So we be very thoughtful in crafting your specification of goods and services. Then there is fragmented filings. Fragmented filings means, that means one day you are filing only the colored mark, and then somebody comes and copies your colored mark with a different color, and then you are not able to prevent enforce that colored mark against that different colored mark of the infringing party. So you have to be, and you have to understand the scope of protection of each and every mark, whether it's a logo mark, device mark, or whether it's a word mark, or whether it's a sound mark or a smell mark. So each and every mark has its own scope of protection, and that should be carefully lined up with the business strategy of the client. Descriptive marks, whether it's a descriptive mark, sometimes descriptive marks over the period of use, they have seen to be acquired distinctiveness because of the excessive use they have for those particular marks. So preserving evidence of use for the descriptive marks is crucial. Then there is poor evidence management, so that has to be corrected by the by advising your client, okay, you have to preserve this evidence of whatever you're using on the bills, whatever you're using on the internet, that all has to be preserved. And then I'll get onto the very interesting slide, myth versus reality. So myth, if the these myths are, what is it? Grant is equal to protection. That is the biggest myth. Reality is grant is just the beginning of your enforcement of your IP right and enjoying the benefits of your IP right. So benefit will not accrue until unless you have a grant. Broad claims are always better. This is a myth. Enforceable claims are much better. This is a reality. More the number of filings you have in portfolio, that is stronger. That's a myth. Smarter filings is a stronger portfolio. Then trademark registration protects the brand. That is the myth. Portfolio strategy protects the business. That is the reality. Next, so let's say, which portfolio would you invest in? Let's say you have a portfolio A or a portfolio B. One portfolio A has 150 patent application. Portfolio B has 45 patent granted patents. Portfolio A has 60 trademark registrations. Portfolio B has 18 strategic registrations. Portfolio A has no filing strategy. Portfolio B has aligned with the business roadmap. Portfolio A has reactive enforcement. Portfolio B has enforcement driven prosecution. Portfolio A has high filing cost. Portfolio B has high commercial value. So which portfolio will invest in? After this today's discussion, I think it would be portfolio B. So the takeaway here is the value of the IP portfolio lies not in its size, but in its enforceability and commercial relevance. Next. Always ask these questions when you are protecting your client's invention. Does the portfolio protect future products? If not, why not? Ask the client. Can competitors design around our rights? Always think about this. Whether there is a design around possible or not, how can I protect the design around? How can I prevent the design around? Then are international markets adequately covered? Is the portfolio attractive for licensing? Is it investment ready? All these questions should be answered by discussing this with your client. Next is preparing for enforcement before dispute arises. These are the best practices which the attorneys, the agents must conduct on a regular basis, which are portfolio audits, competitor monitoring, what the competitor is doing, and how your portfolio looks. That is an important thing. Evidence preservation, freedom to operate law before you launch your any commercial before your client launches any product. There has to be a freedom to operate study. The search has to be done, and then periodic prosecution review and enforcement readiness assessment. Then there are various challenges which are now coming up in the patents realm, which are AI assisted inventions, because what the inventor do is they take assistance from the AI and they say this is AI assisted, and this creates a particular problem because, like in India, the AI is not recognized as an inventor, and hence the human contribution in as an inventor should be protected. So it is always advisable to clients to establish a document or preserving an evidence to show that there is a human element involved when you are conceiving the invention. So it's always better to advise your clients on this aspect, because this AI assisted inventions will have a bearing on this aspect. Then patent analytics and global prosecution harmonization. And thereafter, we get on to the trademark landscape, digital branding, like in terms of your social media handles of your client, or you have your domain names. All these things, apart from the brand name of the particular product or the service, these also should be considered protected by the clients. Online marketplaces, whether there is a counterfeiting or not, taking adequate steps to prevent that counterfeiting and monitoring a watch on these particular types of counterfeitings on online marketplaces is also crucial to prevent or dilution of the particular trademark. Then cross-border reputation, whether your mark is well known, what is the right stage to get into the well-known mark stage and securing a well-known stamp for the particular trademark. That is also important because Indian courts, they recognize cross-border reputation. Then the closing reflections for this are: the successful portfolios are built through strategic drafting, commercial foresight, portfolio diversification, continuous portfolio management, and enforcement preparedness. I think this pretty much sums what we have discussed here. And with this, I close my session, and I thank all of you to be being very patient during my session. And I'm very open to any discussion, any scenarios, any practical insights, and any questions which you have. Thank you so much.
Thank you, Shilpa, for these insightful points. Now I encourage our audience to drop your question in the chat box, and we will address them one by one. Okay, yeah.
Yes.
So, Shilpa, you can see in the chat you got one question from Alexandre. Do you have any experience in dispute regarding polar exemption counterfeit?
So, Alexander, thank you for the question. Your question pertains to two aspects and disputes regarding bowler exemption, counterfeit. With respect to trademarks, I don't have any particular experience, but I am aware of case laws which discuss that. And as regards the bowler exemption in section 107A in patents, I am aware and I've handled cases related to that. If you want me to delve into that bowler exemption part of section 107A with respect to pharmaceuticals, yes, I'm happy to answer that.
All right, Alexander, if you have any input or want to,
Yes.
yes, please go ahead.
Hello. Thank you for inviting me to this event. Okay, so yes, the question is regarding pharmaceutical industry. Um, during your presentation, I checked that the exemption is valid in India. So maybe U.S. experienced attorney have any experience regarding this matter. So the situation is the following: Company A buys active substance from a foreign company, which is still under active protection in our country. So they're interested whether after they get the final product, they can sell that product that is created while the patent is valid, but the selling to be after expiration of the patent, or they must destroy the goods and start producing from the beginning after the expiration of the patent protection.
Right. So, Alexander, if I understand your question correctly, the patent protection is valid in the specific country outside India. You are asking.
Yes.
Okay.
We are
Understood.
talking about Europe, but as I can see, the exception is the same. So I guess that it's similar in both countries.
So in India, Section 107A is what talks about the bowler exemption, and what happens is during the I'm only talking about the Indian law here, Indian patent law here. What happens is if your patent is still alive, and any third party starts manufacturing and exporting the patented product during the life of that granted patent, so that is not permissible even if you manufacture small quantities. So small quantities has to be proven with evidence that only for research and experimental purposes that small quantity is being exported. So if you're able to satisfy with evidence before the court that the small quantity which you are exporting during the life of the particular granted patent is only used for securing regulatory approvals or for research and experimental purposes as per section 107A, that is permissible. Commercial quantities, of course, are not permitted because that's an infringement under the Act. But if you're exporting unlimited quantities, subject to proving that it's only for the regulatory approvals, securing regulatory approvals in any third country, be it Europe, US, XYZ country, and or it could be for research and experimental purposes, then it is permitted and allowed as an exemption to infringement by way of border exemption. I hope it answers to your query.
Yes, that is fine. Okay, thank you. As I could read, it's the same here, but I was just wondering, do you have any experience, so how the things are working in practice? But okay, we are on the same opinion, so that's a satisfying answer. Thank you.
Thank you. Next question is?
Yes, we have a next question from Gasson Datsu. How is IP prosecution different from IP litigation?
Good question. So IP prosecution, it is in terms of practice, it is different from IP litigation, yes. But prosecution is determining the fate of your IP litigation. That is the right answer, I would say. Prosecution covers your search aspect of your IP, whether it's a patent, trademarks, or a copyright, and then it comes to your drafting, whatever you are drafting and submitting to the patent or the trademark or the relevant IP office, and then you are prosecuting the patent or the trademark application. And then you are securing a grant and whatever is the fate of your IP application. That all steps constitute IP prosecution, and IP litigation is before the court or a particular forum, and IP prosecution is before a patent office or a trademark office, which is a quasi-judicial body and not a court. And your IP litigation is before a court, whether it's a revocation procedure, whether it's infringement proceedings, whether it's a counterclaim. So this IP litigation differs from IP prosecution in the procedural aspect. And not to undermine to say that IP prosecution determines the fate of your IP litigation. And the stronger your IP prosecution, stronger your IP enforcement is. Hope that answers your question, or you have further question on this?
Yes. And do you have anything to add? Yes, and Mercy, do you have anything to add? Yes, Sunil.
Bercy has asked this question. IP litigation is done by lawyers.
Yes.
Yes, IP litigation is done by lawyers, but the patent agents can also, there's a provision in the Patents Act, in the Indian Patents Act, the patent agents can also assist the courts on with the lawyers, and so they are permitted to appear before the court of law along with the advocate which is enrolled with that particular bar council and is the lawyer as an advocate under the Advocates Act. So in the nutshell, lawyers definitely, yes, they are permitted to be appearing before the courts and handling the IP litigation, but the patent agents who are registered, they can also appear with the lawyers, and the court may very well hear those patent agents also.
Okay, ma'am. Thank you so much.
Yeah.
All
Next
right.
question.
We have one more question from yes, Roger Zenith.
If you had to redesign, I'll read it out to you.
Yes.
If you had to redesign an
Okay.
ideal IP strategy from scratch to a fast scaling company today, what would be your top three priorities to ensure the portfolio is not just strong on paper but truly enforceable in court? My number one top strategy would be: first, conduct a very good, excellent, impeccable prior art search. As on the date you are filing your application, the search should be stopping on that date. It should not be a month back you had conducted a search and after a month you're filing your application, because that 1 month data would be missing. So please bear in mind that aspect. Second point is claim drafting has to be very strong. And my third important step is that you should have a very clean prosecution. What I mentioned, that your each and every statement should be, I would say, sieved through and funneled through a very proper uh, diligence and an examination of what to say and what not to say in your prosecution. Because if you understand what you have to say and what not to say, that will create the future of your granted patent or your trademark, and that will help you in your the IP litigation enforcement. So my three top ones are those. Do
Okay.
you
Again,
use
a question from Alexander.
Yeah, Alexander, do you
Yes.
use any AI tools? So we don't have any specific AI tools which we use as far as this goes, but definitely we for the regular research and any particular assistance on I would say refining the particular scope, but you with the chat GPT, definitely. But we are not giving anything and everything in detail to these portals like chat GPT, because then you are giving everything in the public domain. But you can definitely paraphrase the paraphrasing part is what can be done through chat GPT, but not each and everything through these AI tools. So you must bear in mind how to carefully use these AI tools, because no tool is 100% perfect and there's a risk also.
All right. So, audience, do you have any other question or any input to add? Definitely got them. Dr. Shilpa will add you, or you can also send a request to Dr. Shilpa over LinkedIn.
Yes.
Yes, audience, do you have any question to ask to our speaker today?
Yeah, I just want to clear one thing. So here in patents, IP prosecution starts right from the searching and then filing and then everything like examination, response to the examination report and getting patent granted. Is that all those stages called prosecution, or is there any particular stage is called prosecution?
All those stages include prosecution, and this also should not be forgetted that renewal of the trademark or their patents is equally important and constitute the prosecution. It's not just stopping at the grant. You should not be happy saying, okay, I've not secured a grant, because if you don't renew your IP right, then it's gone. It's in there in the public domain. It has lapsed. So renewal is again the last step until the life of your IP right. All
Got
these
it.
collectively include your prosecution.
Okay, thank you.
Yes.
Yes, audience. Any question? Yes, we
Another
have one
question is there. Gershan has was particular question. How does a trademark which has distinctive loses its distinctiveness? Any example in the market? So you're asking if a mark is distinctive initially, it will lose its distinctiveness with the period of time. An example in the market. Very good, very good question. So example is Xerox. Xerox was initially a coined mark and has been a coined mark all through this while, but people started using in India with respect to photocopying. So somebody will say, okay, I want to get the Xerox of this. So Xerox is not is synonymous with the photocopying. So people started using this photocopying term with and replacing that with Xerox. So Xerox actually had to take enforcement action. If you see the litigations and the court files, it clearly says Xerox was losing its distinctiveness and was being diluted as a distinctive mark. And because of this practice in the market, Indian market, that simply people were replacing the term photocopying with Xerox. So rightful enforcement action of a distinctive trademark and monitoring of this distinctive trademarks is crucial so that the mark is not diluted over the period of time.
Ma'am, I have one more question. Is all the patents are monetized and used by the companies or everywhere, or it's just like a granted patent and then they have it as a resource? I mean, as a asset. Because we are I'm a registered patent agent, so I worked just 6 months only. I'm just looking for job. So in that we have drafting and giving response to FER, and the patent stage getting granted is take minimum 6 months, and then that patent is getting is getting monetized or used by the other companies or industries, or I think many were just granted and they had it as an asset. Is it so, ma'am?
So, if I understand your question correctly, not all the patents which are granted have to be monetized. It depends upon the business entity whether they want to monetize that or not. It also depends upon the strength of that particular patent, if it is actually capable of being monetized or not. So, depending upon the strength, the value of that particular patent, the decision has to be taken by the business entity whether they want to monetize or not. So there's no hard and fast rule that a patent which is granted has to be monetized. That's why if you see in the working statements form 27 which you filed before the patent office, you just have to tick mark whether it's worked or not worked. So it's not mandatory that you have to monetize it, license it. It is not an important this thing which has to be check marked. What is important is whether the client is interested in building a monetization or a commercialization out of that particular patent, and whether it's actually liable to be commercialized, because not all patents you see are liable to be commercialized. They're not even strong enough. They are not even covering the scope of the particular product. So that is very important exercise when you are commercializing or monetizing your granted patent. I hope that answers.
Yes, ma'am, I understand.
Yeah.
Thank you.
Yes.
Okay, we have one question from Gautam. Like he raised his hand. Gautam, please.
Am I allowed to speak, ma'am?
Yes,
Am I
please.
audible?
You
Yeah.
can speak,
Yes,
please.
yes.
Yes,
Yes,
yes.
Gautam.
First of all, Shilpa, ma'am, thank you for such an informative session, ma'am. I
Thank
had a
you.
doubt that if I have an invention granted a patent in US, so
Hmm.
if I apply in India for that patent protection, so can I refer to that US patent that is already been granted, and can I say that my patent is already been granted in US? So that's why it is novel. It is has inventive step. It has industrial applicability, and it fulfills all the criteria of Section 3 as per Indian laws, Indian patent laws. So can it be my point before the examiner that my patent should be granted with reference to that US patent that has already been granted?
Okay, Gautam, understood your question. So, while during the examination stage, you're trying to say that you can place a persuasive argument before the controller that since you have already a granted US patent, so the Indian patent ought to also have been granted. So, this has been a settled position of the law with respect to the by the Indian courts that it is not material that if a patent is granted in X country outside India, that should the Indian patent also should be granted. That is at max a persuasive argument, but the Indian Patent Office will do its own inquiry in terms of novelty, inventive step, and industrial applicability and patentability. Because see, the patentability under Section 3 is completely different, which is different from the US. If the prior arts, coming back to again the prior arts, the grounds, novelty, inventive step are identical, I would say. as that has been there against the US patent, you can always have a persuasive argument, but that is not incumbent on the patent office controllers to accept this and give it to you on face value. Since you have a US granted patent, okay, we are giving you the grant of Indian patent. No, it's not like that. You have to satisfy the patent office on the counts of your novelty, inventive step, and industrial applicability and patentability, and all other claims, the scope aspects which are there in your examination, and has to be independently satisfied before the controller of patents. At max, if you encounter those prior arts and the grounds are identical, you can have this persuasive submission before the patent office. I hope it answers.
Yes, yes, ma'am, it does. Another question, another doubt, that has there been a case law for that? Is there a case for
Yes,
that?
yes, there
A
are enough
judgment?
case laws. There are 2 to 3 case laws which talk
Can
about the effect of the foreign patent prosecution before the Indian Patent Office. I think I remember there's Justice Pratibha Singh's judgment also on this. I don't remember the exact cause title of that, but there is, if you see Justice Pratibha Singh's decision on the effect of the foreign prosecution history on the grant of Indian patents, you will get it.
Okay, okay, ma'am. I'll do check
Yes,
it, check that.
yes.
Thank you for answer.
Okay. Any other
Uh,
question?
yes, a last call to our participants if you have any questions. No, I think it's a really very informative session. We received a very pretty good question from the audience. So
Yeah,
thank you, Dr. Shilpa, for that very informative session. Even I enjoyed a lot.
thank you.
And thanks to our audience for such active participation and thoughtful questions. So we hope you found this session very informative and engaging. So on behalf of International Intellectual Property Law Association and Dr. Shilpa, thank you once again for joining us. Have a great day ahead. Thank you.
Thank you.